To get further perspective, we're joined now by legal practitioner Raymond Nkanebe. Raymond, thank you for giving us your time. How would the proposed amendment address the anomaly in the current electoral act?
All right. Thank you very much, Felicity, for having me, and good evening, Nigerians. So the event you mentioned, rightly so, it was a seminar organized, or a workshop organized by the National Assembly in collaboration with other critical stakeholders in the justice process, particularly the judiciary and also other civil society organizations. And at that session, the Court of Appeal made some number of proposals to the amendment of the Constitution, which will also have bearing on the electoral jurisprudence. I think a couple of them, particularly one that actually stuck out for me, was the proposal that to the effect that in the event where a governor-elect happens to be affected by a disqualification on his or her running mate after they had been voted into office, the disqualification of his running mate should not affect his or her qualification. And that was in response to what happened in Bayelsa in 2020, where the APC and David Lyon had won the main election. However, on the back of a pending pre-election case affecting his running mate at the time, that is Mr. Adegi Yogorakuma, it happened that while he was preparing to be sworn into office, this Supreme Court decision disqualifying his running mate's qualification for having been involved in falsification of his educational and other documentation. So it's operated to disqualify both of them. And at the time, I recall some of us in the civil society space took up objections with the Supreme Court's interpretation of that provision of the Constitution, particularly Section 187. But as it turned out, the deed had already been done at the time. So I'm happy that now the Court of Appeal itself, being a very, very critical stakeholder in the election process, has proposed these reforms. And what we're likely to see is that when this proposal becomes the product of a legislative process, then we can be sure that such a situation in the future is not going to repeat itself. And it will have two purposes. The first one is that it's going to increase attain the goals of franchise, because the situation whereby the masses have voted in someone into office, and because of what happens to his or her running mate, it now affects his candidacy.
Yeah, that brings me actually to the other question I'd like you to actually spend a little time on. How does the proposed amendment align with the principles of electoral justice and fairness, like you just highlighted? Because it was an election. People chose a particular person. Whether there was documentation issues or not, this should have been treated before now. So how does that align with these principles?
Yeah, absolutely. That is the major response of this proposal, like you rightly pointed out. So what you can see is that when the masses go to vote, so whoever they voted will eventually become their ruler, as the case may be. In terms of other reforms that were proposed here, we're talking about the speed of determining election matters, and also a case for the finality of election matters to terminate at the Court of Appeal for pre-election cases, and also for governorship and National Assembly elections. The current status quo, you have a situation whereby matters go all the way from the tribunals to the Court of Appeal and all the way to the Supreme Court. This takes so much time, so much resources on the judicial process, and also affects other cases that should be actually be in the docket of the judiciary. So with this proposal, if it becomes an act of National Assembly, which leads to a constitutional amendment, you can see that election matters will terminate at the Court of Appeal stage. National Assembly matters, Court of Appeal stage. Only elections into the office of the president will now make it to the Supreme Court. So I think, in a nutshell, some of these reforms are a response to what stakeholders in the election process have been clamoring for. And I'm happy that the Court of Appeal itself is in the forefront of this advocacy. And I hope the National Assembly picks up some of these proposals and grasp them into legislative bills for possible amendment of the 1999 Constitution.
Raymond, thank you for speaking with us.
You're welcome.